a lot of attendees still on the line. I just didn't know if that was...
Mr. Weaver bail. I wanted Mr. Weaver to stay and take ethics training with us. He's a lawyer.
We could all stand to benefit from some good ethics.
That absolutely. I just don't know who. I don't know who these callers are. So I just want to make sure. I mean, not that we're going to discuss anything, but I'm curious why we still have people on.
I just stayed on.
Yeah.
Multitasking.
This is Don Trey with ITS. Could call us 630. Identify yourself, please.
Who is John Jenkins and who is Andrea DiNapoli?
Andrea spoke earlier in the public engagement, and Mr. Jenkins is a longtime event promoter. If it's the same John Jenkins.
Just move on.
Don Trey with ITS. Mr. Jenkins, you are unmuted. Can everyone else hear me?
Yes.
Yes.
Yeah, I just maybe we just move forward unless there's some reason we need to have them off or anything. I don't think it prevents us from moving forward.
Okay.
Yeah.
If you all are comfortable with that, I'm comfortable starting. Okay.
I guess I'm comfortable with it. I think it's a little strange.
I'm guessing. I mean, I just know from my work Zoom meetings, that people multitask and do other things and just left it on or moved it.
Yeah, I'm just watching Mr. Jenkins go on and off mute. So I don't know. Don Trey, is there any way to limit it to the board members who this is for?
Madam Chair, I would advise against that because this is technically part of the open meeting. So if people want to attend.
I didn't know that. I thought this was a special.
Yeah, no, this has got to be, it's sort of a hybrid. It could be done as a separate training session, but I think because it's brought together, it actually makes sense. And this way you all can actually have some discussion too, in case there are questions. So this makes it a little bit freer for you all to be able to have more discussion. You obviously wouldn't vote on anything related to this, but it just makes it a little bit cleaner to have it as part of your regular meeting.
Got it. I was unaware of that. Sorry.
No, it's okay. Okay, so basically this training came about in response to, as part of the mayor's Blue Ribbon Commission that he did when he first came into office on open government. He put together a group to just advise on some ways to make government more open to the citizens of Davidson County. And one of their recommendations was that there should be annual training on ethics for boards and commissions. So they've asked the Department of Law to put that together. We combined that with some other training that we thought would be helpful, including training on the Tennessee Open Meetings Act, a little bit of Public Records Act, and a little bit about electronic meetings in the limited amount of time that we're going to be able to have them. But with the idea that it's always possible that electronic meetings may be used as a guide for future legislation to enable this to happen more permanently. So we put this together. It's about 30 minutes to 45 minutes. Could be shorter, could be longer, but we'll get right to it. I know you all have had a busy slate of meeting already. So let's see. The goals of this training: understand that you cannot accept benefits related to your role on the board. To understand when you may be biased or have a conflict and should recuse yourself. To remember to disclose knowledge you've received on an agenda item from outside the meeting. To remember to articulate the specific reasons and basis for your decision, and to understand that the Open Meetings Act prohibits deliberation outside board meetings, and the Public Records Act makes almost all of your emails open to the public. And finally, to understand best practices for making informed decisions. So the first one is to understand that you cannot accept benefits related to your role on the board. There are certain benefits that, as you'll see as we go through this, that you can't accept any of, and some you can accept some of. And understanding the difference between these two is very important. It's all contained in Metro Code Chapter 2.222. If you look at this code provision, and I strongly encourage any board and commission member to look at it just so you can have a generalized understanding. It's also a good quick reference in case some ethical issue comes up to you and you want to say, okay, is this appropriate for me to accept this kind of benefit? You can look on the code. You can see exactly what's required and what's not. It's important to note that the code is written in a way that is not, some code provisions that you may see over time are very specific, and the ethics provisions tend to be more vague. And the idea is to make sure that with any instance where you might be presented with an ethical conflict, that you have to ask yourself, okay, is this appropriate? And that's why they're written the way they are. And you'll note that when you review them here. So first, there's the prohibitions, what Metro employees cannot accept. And for purposes of this, board and commission members are Metro employees for purposes of this provision. You can't accept or solicit any benefit that may reasonably tend to influence you to act improperly in the discharge of your official duties. So note that it doesn't say that it does influence you, but if it's reasonably tend to influence someone to act improperly, then that's the case. So the idea there being that, you may say to yourself, well, you know what, if you gave me this 55-inch TV, it's not going to change my vote. But I think most people would say, well, that reasonably would influence your vote on something. So that's a kind of a grandiose example of how that would work. Using Metro property, services, or funds for personal purposes. Obviously, as board and commission members, you may not have access to certain funds, but certainly it would be improper to use Metro's property or its services in some personal way. Use non-public Metro information for personal gain or for the gain of a family member or other employer. Oftentimes this comes up in the certain databases that boards and commissions have ability to access certain information. Not so much for the Fair Board, but for others, certainly you would be improper for you to use information contained in that database that was not a public record for some type of financial gain or for a family member or for an employer. Next is, again, with the shall nots, use a Metro position to improperly secure unwarranted privileges or exemptions for themselves, relatives, or others. Obviously, like when you all there are a lot of events that come to the Fair Board. So an good example for you all would be improper to use the position as a Fair Board member to secure these types of benefits for yourselves that the public could not get on their own. Accept other employment which might impair their independent judgment in the performance of their Metro duty. Again, sometimes this comes about when there's interests that coincide. If there's a vendor that's used at the fairgrounds, it might be improper for you to accept working for them. Obviously, you review all these on a case-by-case basis. Accept any benefit which the employee should reasonably believe was intended to influence any action taken in the employee's official capacity. So this kind of clarifies the difference between the earlier one, is that if you think someone tried to give it to you to try to influence your vote, no matter what the value is, it's improper to accept it. So you can accept some benefits if no conflict or appearance of conflict otherwise exists. Awards of trifling value, publicly presented in recognition of public service. So oftentimes in Metro, we have these for years of service for regular Metro employees. Obviously, trifling value is the key there. We get a pin, we get a little letter. If you get a pink Ferrari, that is not going to be trifling value for recognition of your public service. Gifts unrelated to a person's position as a Metro employee. A lot of times people have relationships outside of Metro, and if you're getting gifts as part of your regular Christmas routine, and it has nothing to do with the fact that you're a Metro employee, then those are permissible. Meals, beverages, food, promotional items, or hand-produced items of a value up to $25 from a single source in any calendar year. So remember, this is a single source. So if for some reason there's a vendor, a caterer that were to show up to a meeting, and as part of it, they had a presentation related to it, and there was food presented. So long as the food was not over $25 and it wasn't the same vendor more than once in a given year, then this would be acceptable. And different boards and commissions have instances where this type of thing happens. Also, if you were to visit a vendor who is looking at something or And again, if they produce some food, a lunch there, this is enabling you to have that lunch. Obviously, if it's a fancy lunch and it's clearly more than $25 what the value is, then you would need to pay the difference of that to make sure that you did not go over $25. And finally, free or discounted admissions, tickets, access to events, or travel expenses from any single source of an aggregate value in any calendar year of up to $100, or tickets of the face value in excess of $100 if the event is generally recognized as an annual fundraising benefit sponsored by a nonprofit. So, we talked a little bit earlier in the meeting about Big Brothers Big Sisters. If they have an annual nonprofit event, it's over $100, you're not prohibited from attending that. And also you can attend other events, again, so long as the $100 rule is followed. So the Metro Board of Ethical Conduct is who reviews whether employees are abiding by these standards. The Board of Conduct is created to hear these complaints. Any elected official or member of the board can request an advisory opinion. This isn't often done. What I usually tell my boards and commissions is, if there's ever an issue that comes up, a question about ethics related to these rules and something that's happening with you, while I don't represent each individual board or commission member individually, I'm happy to tell you in my experience how these type of situations typically play out in terms of the advice I would otherwise give you if you were a client, and you can kind of make your own decision about that. But there is officially a way to seek advisory opinions from the Board of Ethical Conduct. The complaint procedure is outlined here. Basically, the Department of Law, a complaint is submitted from anyone. The Department of Law investigates and makes a statement about whether or not it would be an ethical violation if true. The board can hold a hearing. Parties are given an opportunity to present both sides. Penalties for violations can be very severe. Recommendation to counsel for censure that the person resign their position. It can be referred to the DA if there's a criminal prosecution, or to the Director of Law if there's a request for restitution or other civil relief. Okay, that's goal number one. Now we're on to goal number two. Understand when you may be biased or have a conflict for which you should recuse yourself. You as board members have a duty of independence. You can't act in self-interest, based on your self-interest, bias in favor or against people you know personally, or bias on the interest of the director or contractors with whom your board interacts. So your duty is to be independent with the knowledge base for which you were put into this position. So some people ask questions, well, like I have this particular area of expertise. Do I need to just set that to the side? No, that's part of the reason that you were asked to be a board or commission member. You're supposed to use your areas of expertise to help inform your opinion. You must be impartial and act based on the law and the evidence presented to you. That's an important one, because I think sometimes people, it's important for the board or commission when you make votes to articulate the reasons for them, and we'll talk about that a little bit later, but acting on the evidence in front of you and articulating why the evidence has persuaded you is an important aspect of any board or commission member's decision. Okay, I have a conflict. Should I recuse myself? Yes. If you are biased based on personal interest, if your family, you or your family are going to lose or gain money based on the decision, or you're biased or prejudiced for or against a group for any number of reasons. If you believe you cannot make an impartial decision because of the bias you have for or against this group, it's appropriate for you to recuse yourself at that point. You cannot fairly or impartially weigh the evidence because you have prejudged fact issues. That's you may be not biased against the group, but the facts you believe you already have an opinion on, and you can't make an impartial decision. No, if you will not gain or lose money fairly directly from the decision, and you can be objective and do not believe your participation will create an appearance of impropriety. So remember that part of this is actual impropriety, and part of this is appearance of impropriety. We want to make sure that the board's decisions don't look like they're. It's important both that they're not inobjective, but also that it doesn't look that way. So it's important to remember if you have something that comes up, the earlier you can address that with Laura, just ask her about it. She can always refer it to me. The sooner it is that we can give you good advice on what to do about these. Goal number 3, and back to the goal number 2. Remember that one of the problems with the appearance of impropriety issue is that if it looks like it's improper, there's a possibility it can become the subject of a lawsuit, and then the decision can be overturned on appeal. Number 3, remembering to disclose knowledge you have received about an agenda item from outside the meeting. You want to disclose knowledge from outside the meeting or recuse yourself. An example of this comes up a lot in land use. We'll have an instance where someone will be voting on a BZA variance, for instance, and they'll say, well, I actually drove by this property and here's what I observed. That's what it's appropriate for you to make that statement on the record and then make a vote on it, because you have some individual experience that the other board members might not have. And so you want to disclose that. And there are some things like that. If it's something you personally observed, you can make that disclosure and still vote. Obviously, that's much different from, hey, I have a financial interest in this vendor. I cannot vote here, no matter what my participation level. Knowledge can also include attempts to lobby you outside the meeting. That's something that would need to be disclosed to the group before you vote. Or your expertise or experience with this type of issue or area of town when making a decision. So that's we always have, for instance, you may have people who have expertise in event planning, and you're making decisions about what kind of events come to the fair board. If there's something that some level of expertise you have that others do not, you want to make sure to just disclose that. Well, I worked as an event planner for 10 years, and I think this event can be carried out smoothly at the fairgrounds with no problems. It's just helpful to let everyone know that the reason you're basing your decision isn't just the evidence right in front of you, it's also based on a history of knowledge. Okay, goal number 4, remember to articulate the specific reasons and basis for your decision. So I spoke about that a little bit before. Acceptable reasons for making a decision is 1, the criteria in the relevant guidelines or laws. You'll often hear us refer, and Laura does a really good job of this too, just referring back to what the bylaws say, referring back to what the code says, to what the charter says, to what the private act says. The reason we do that is partly to inform the audience, but also partly to make sure that any vote that's taken is done with the appropriate guidelines or laws in place, because that forms the basis for your decision. The facts presented at the meeting, it's important to remember that if it's not presented at the meeting, it shouldn't be assumed that it's in the record. So it's the duty of applicants, duty of people who are seeking to sway the board's opinion one way or the other to present certain facts. And it's appropriate for the board to then weigh those facts based on how important they are to the decision. Past experience with similar issues is also appropriate. How the board has handled things in the past is certainly relevant to how it handles them in the future. And studies by experts or specific observations made by the public. Those can all be factored into the decision. Unacceptable reasons for voting would be sympathy for the applicant or for people who are opposed to the approval. Obviously, if the basis for opposition is something that's part of the guidelines, part of the law, part of the appropriate basis, that can be used. But simply because there's people may have certain aspects that pull at the heartstrings is not an appropriate reason for voting for or against them. Or opposition that is not based on relevant guidelines or laws. Sometimes people will have opinions about certain matters that don't actually have, that are important, but are not part of the laws with which you're reviewing. And so the example here that they use is a demumbering case where the board knew that there was a history of some bad behavior by this particular applicant, but none of that was put into the record, and they simply denied the application without discussing that. And the court found there was insufficient evidence in the record to justify denying the permit. So it's important that all the things that you think everybody knows, make it into the record and make it into your discussion about why you made the decision you did. Number 5, understand that the Open Meetings Act prohibits deliberation outside board meetings, and the Public Records Act makes almost all of your emails open to the public. So we'll handle the second part first. It's pretty straightforward. Public Records Act means that anything you send by email be it your personal email or your work, if you have a Metro designated Nashville.gov email, is subject to public records. Any document you create as part of your duties working on the Fair Board is subject to being turned over in a Public Records Act. Now, sometimes they might not be turned over for various reasons, but you need to assume for purposes of when you create a document related to being a board member, you need to assume that the whole public can see that document. So because sometimes if we get a public records request, we'll ask each of you, or we'll have ITS conduct a search to make sure that we have all the documents necessary to produce. But almost all of them get produced. And I think sometimes board and commission members struggle with that concept that, hey, I sent this from my personal email address, this should be protected, and it's simply not. So, okay, so in accordance with that, you should absolutely avoid the use of email to discuss board issues or invite comments from other board members concerning public business. A lot of times, sometimes you'll see an email that will go out from Laura. Oftentimes, I'll advise staff to send emails to the group with a blind copy if it's something that has to do with substantive matter. Obviously, if Chrissy sends out an email saying, hey, we're going to have the meeting at 8:30 instead of 8 o'clock, or hey, here's the agenda, it's not a big deal to just send it to everyone. It's a small board. But when it comes to substantive issues, a lot of times you'll see blind copies, and the purpose for that is to make sure that no one replies all and inadvertently has some type of discussion or question about it that could lead to a court believing that there's some type of deliberation going on. We talked about how it doesn't matter whether the email is a Metro email or private. Violations of the Open Meetings Act make decisions based upon those deliberations void. So it's a very severe sanction, basically as though the corresponding vote never happened. The judge may also order court supervision of a board. We've had that happen before. So just one of those things to be very careful of. If you ever hear me jump in and say, hey, we're doing deliberation in a private meeting, sometimes we have attorney-client meetings or things like that. That's why we're just trying to protect the integrity of your future votes.
Hey, Alex, can I ask a question on that?
Yeah, go for it.
And also, I want to apologize again. I did not realize the sort of run of show for this meeting, so I didn't mean to try to make it private when it wasn't. But backing up to the private email, can you back up one slide?
Sure. Well, I can try.
Oh, sorry. Well, I think it just said that almost all of our private emails are public record. Is that only emails that are concerning? Oh, I'm sorry. I screwed this up. No,
I'm terrible at tech. It's not your fault that I'm bad at tech. So,
I'm basically just curious because we've had this come up before where we've had in Discovery had private emails that we had to submit, which is totally fine. But I'm just curious, when it says almost all emails are open to the public, are those only ones that concern the fairgrounds?
Yeah, yes. I mean, okay. The idea is that it's anything that has to do with your business as a board member. That's the key part, right? Like, right. You wouldn't have, if you're emailing some type of recipe to Commissioner Bergeron because you two share an affinity for key lime pie, that would not be related to official board business. Although you should always share your key lime pie recipes with the rest of the board members.
I'll blind copy everybody, don't worry.
Good. But that is not related to any board business. And so it would not be something that we would turn over. Now, it might be one of those things where if we get a request for it, that we would ask for all emails among the board members, and then the legal department and the staff would review to see what's relevant to the question posed in the public records request.
Sure.
But if you have, and also if you have other business emails related to your own non-Metro emails related to your own activities, those would not be subject to disclosure. So,
okay.
But that's a good question. And when and we don't have any, just speaking from a practical standpoint, we don't have any ITS control over your own personal email. And so it's typically, if there was a request for personal email information, we would be asking you, hey, can you please produce this information? But it is subject to disclosure. And so I always encourage people, if you have concerns about whether or not you'd have to produce something from your personal email, you can also always create an email for your Metro business. You can either ask, Laura may be able to work with ITS to get you an email that's a Nashville.gov email, or you could create one specifically for your position as a board member. And then it's a little cleaner to be able to say, okay, I know that this email is just board business, and that's what I would be producing as far as a records request. Just make sure you don't do any board business on your other email. Does that make sense?
Yes, absolutely. Thank you for clarifying that. Sorry, I didn't ask that because I have anything to hide. Obviously, I just never seen it written like as such, like almost all of your emails are.
Sure, yeah, and we get that question a lot. A lot of people have questions. Board members, commission members have questions about how the interaction of their email versus the public email. So it's a very regular question I get.
Thank you.
No problem. What's a meeting for the purposes of an Open Meeting Act? It's real simple. If two or more of you gather together and you talk about business, that's anything more than, hey, what time is the meeting? That can be considered a meeting that should be subject to Open Meetings Act. So it's one of those things where I think a lot of people, they seems like a cruel and unfair way to conduct public business, but that's what the state law says. And it basically says that if you want to talk about things like you all talked about today, figuring out what your meeting schedule would be going through the summer, you can't do it anywhere else but the public meeting. So now, and the keys to what happens when you have a meeting, you all know some of these, but we have to give adequate public notice. The notice has to inform affected parties of the opportunity to be heard, give them a time to prepare for and anticipate the meeting. Courts have determined that adequate public notice is sufficient notice under the circumstances that would fairly inform the public of the meeting. So as you can see, that's an incredibly vague standard. And we've had cases before where 48 hours was found to be insufficient for notice for a specific issue. And there have been cases I know where it's been found that that's sufficient. So it really is a case-by-case basis, what is sufficient public notice. So the following are not considered meetings so long as there's no decision-making and deliberation toward a decision. One would be an on-site inspection. If there was any, for instance, once the stadium is complete, if you all are invited to go out and take a walkthrough of it, and you're just pointed, that Ms. Kabara simply points out where everything is and takes you on a walkthrough, and there's no discussion about anything, then you're good to go. However, if you all suddenly decide to go into one of the locker rooms and have a bunch of discussion about board business, you've turned an on-site inspection into an open meeting. So it's important that you stick to the script as to what you're there for. A chance meeting or informal assemblage. So if you two happen to run into each other, two of you run into each other in the grocery store, you don't have to like run away from each other and pretend you don't know each other. You can, that's a chance meeting, it's appropriate. Again, as long as you're not discussing board business. And finally, attorney-client meetings. We've had a couple of those over the years. As you know from that, we have a pretty strict protocol. The attorneys speak, you all respond, you all ask questions of the attorneys respond. We keep a pretty tight rein to make sure that there's no discussion among board members, even in those meetings, because that could turn a otherwise appropriate closed meeting into a meeting that should be publicly noticed. Electronic meetings under the governor's executive orders. I'm going to go through this quick because we're probably only going to have this for this last meeting. Basically, you have to make the recitation at the beginning. You have to do roll call votes. The meetings have to remain open for the public to participate. Recording must be made within 2 days. You're encouraged on the agenda to identify how the public can watch and put an agenda on it, which we do. You have to reasonably identify yourself. Public comment should be similar to what it was before. And then goal number 6, finally, best practices for staff. We always just like to make suggestions and recommendations. If the agenda is detailed and provided to the board members at least a week ahead of time, that's helpful. Public may also be informed of issues to be deliberated or decided. One of the benefits of having a more detailed agenda is the public is more informed. The downside to it is it may limit what it is that the board can do when it appears. So it's oftentimes we'll work with Laura on agenda issues. If she says, hey, what should it say? And she and I work on a pretty regular basis on that. So the agenda is pretty thoroughly reviewed by the time it gets to you. Also, if there's ever anything where there's a staff recommendation, that's not often the case for you all. Usually that's reserved for more land use stuff. But if there's ever an issue where there is a staff recommendation, to put that in the agenda itself or in a presentation so that the board knows what they're voting on specifically. And finally, start each meeting with a declaration by any board members of conflicts or recusals on agenda items. So if you know you're going to be out for something, you say that at the beginning, and then it gets noted for the record that you did not deliberate or vote on that issue. More best practices, make sure you understand your department. We encourage board and commission members. You all are obviously longtime veterans, most of you. But if you have questions about how the operations go, then go for a site visit. Go talk to the staff, have them explain what each of their jobs are and how they go about preparing the reports that you see. It will allow you to ask more informed questions. If there are documents that are relevant to board agenda items, request them that they be sent out to everybody so that you can review them. If you have questions about what you're reviewing, call the staff members and ask them to explain it to you. That way you can have an informed vote. And you can also consider adopting metrics for your board to measure whether you're acting timely or in accordance with your board's duties. So if there are certain measurable ways to do that, you can always look to try to improve your efficiency. Some boards take, regular attendance to make sure that everybody's appearing. There's all sorts of metrics you can use to make sure that each board and commission member is participating. And finally, if there's any questions, you know how to reach me. So anybody have any questions about any of the Ethics or Open Meetings Act or Public Records Act issues presented today? If not, I release you. You're free to go. Thank you for your
Thank you,
participation in
Alex.
training.
Thanks so much.
Thanks,
Thank
Alex.
you,
Thanks,
council.
everyone.
Thanks.
Bye.